Okay, good afternoon once again. We are still on law of contract. We know what a contract is. We have also talked about the types of contract. We also talked about the essential elements of a valid contract. The last time we met, we picked offer. We learned about what an offer is. And we also talked about types of offer and other aspects of offer. Today, we are going to conclude on our topic, offer. And so we have two other aspects of offer to talk about. We'll be looking at the rules of offer. Then we also look at termination of offer. So rules of offer and termination of offer. Now remember, when you say rules, what are we talking about? You see, there are certain factors that should be present for your offer to be valid. If an offer is not valid, then acceptance cannot take place. There can never be an agreement if the offer itself is not valid. So for the offer to be valid, there are certain rules that the offeror, for now when I say offeror, you know who the offeror is, the one who makes the offer. There are certain rules that he should or she should follow in order to have a valid offer. So by the end of this lesson, you should be able to give at least 4 rules of offer. Now we are looking at the essential elements of a valid offer. So when I talk about rules of offer, I'm talking about the essential elements of a valid offer. You remember we have talked about the essential elements of a valid contract. But here we are looking at offer. So the rules, we are looking at the essential elements of a valid offer. For an offer to be valid, you must obey those rules. Then too, you should be able to state and explain 4 ways by which an offer may be terminated. When you say an offer had been terminated, what does that mean? That means the offer has come to an end. And we shall look at ways by which an offer can come to an end. Then finally, whilst we are talking about ways by which an offer can be terminated, we'll be looking at another concept called the postal rule. The postal rule. So by the time we finish with it, you should be able to explain how the postal rule affects offer and how it affects acceptance. So that is that. So now let's start. Rules of offer. Rule number 1, you already know. We have learned a similar thing. So you know the rule. Number 1, when you are making an offer, the rule is that it must be definite and unequivocal. The offer must be definite and unequivocal. When you say unequivocal, it means it should not be ambiguous, so unambiguous. So it should be definite and unambiguous. And the word ambiguous, you remember in one of our lessons when you were in school, we learned and we talked about when you say a particular statement is ambiguous, what it means. And you remember I gave you a certain example and I asked you to tell me what it meant. I said I killed a mosquito in my pajamas. And I asked you what it meant. Then somebody said that it meant I was wearing pajamas and then the mosquito was inside the pajamas and I killed the mosquito. So the mosquito entered the pajamas and I killed it. Then I said, what does it mean again? Then after discussion, we realized that it can also mean that I was wearing pajamas when I killed the mosquito. So the mosquito may not necessarily be inside the pajamas. But then I was not wearing this coat. I was wearing pajamas, and the mosquito was somewhere here on the wall, and I squashed it on the wall. By the time I killed this mosquito, I was wearing my pajamas. So either the mosquito was inside the pajamas and I killed it, or I was wearing my pajamas and I killed the mosquito. So you see, one word can give two different meanings. So when a sentence, no, not one word, but one sentence can give two different meanings. So when a sentence can give two different meanings like this, then in English they say that it is ambiguous. So when you are making the offer should not be ambiguous. It should be unambiguous. It should be unequivocal. It should be definite. What does that mean? It should be clear. It should not lend itself to several interpretations. If, for example, you said, my passport is missing, anyone who finds and reports and returns the passport will be given a handsome reward. The question we have to ask ourselves is, what is handsome reward? Now, when you say a reward is handsome, what is it? Your interpretation will be different from that person's interpretation. So it means it is not definite enough. It is not clear. It is ambiguous. So when you are making an offer, let it be so clear. For example, my passport is missing. Anyone who finds and returns the passport will be given 500 Ghana cedis. You see, this one is clear. Can't we measure 500 Ghana? It's definite. And it's clear. It's unequivocal. So that is number one. An offer must be definite and unequivocal. Unequivocal, another word is, it should be, the offer should not be ambiguous. It should be unambiguous. So that is that. The next point, another rule is that when you make an offer, the offer must be communicated to the offeree. Remember, the one who makes the offer is called the offeror. The person to whom the offer is made is called the offeree. So the offer must be communicated. You cannot say you have made an offer and it's in your head. You should, the one to whom you made the offer to should know that you have made the offer. The one to whom the offer is made should know that you have made the offer. And we are going to use a case to show that if you make an offer, if you made a performance, it means if you did something and you did not communicate to the other person before you did it, it means that you did not communicate the offer to the person for the person to either accept the offer or reject it. Remember, when you make an offer, the person can either accept it or reject it. So when you make an offer and you don't communicate to the person, then there is no valid offer. And that was what happened in the case Taylor versus Lade. Taylor versus Lade in 1856. Now, Taylor was a captain. You know, for now, you know that when I say who is the defendant, you should be able to tell me who the defendant is. When I ask you who is the plaintiff, you should be able to tell me who the plaintiff is. So the defendant, the plaintiff was a captain of a ship. And this captain, the ship was on voyage. When you say voyage, you know we are talking about journey, a long journey by sea or by space. Voyage. Whilst they were on course, he resigned. He said he will not do the job again. He resigned. So another captain took over. You know, when you say the captain of a ship, you know who the captain of the ship is. So he resigned during the voyage. Now when he resigned, now he has resigned, so he's no more the captain. He rendered certain service whilst he had resigned. So when he came, after the journey, when they came back, he told the ship owner that he should be paid for the service he rendered. Then the ship owner that is late said he will not pay him the money. They said, I have rendered service, so pay me. So Taylor now went to court. He sued late to pay him for his service, for the work that he has done. What did the court say? The court said that Late was not supposed to pay the money to him. Why? Because Taylor did not communicate the offer to Late, for Late to either accept it or reject it. You have resigned, so you are no more the captain. If you have resigned and you are no more the captain, the work that you did you ask me? Did you ask him? Did you tell him that, please, even though I'm no more the captain, there is this particular service I want to render, because if I don't render this service, there will be problem. The ship might not even come home. So with my experience, I've been involved in rendering that service. Then the defendant would have said, no, don't do it. Yes, do it. But he did not communicate to the defendant, and then he rendered the service. And once he did not communicate to him and he had rendered the service, then the court said that because of this rule, offer must be communicated to the offeree. Taylor did not communicate that offer to render the service to the Late, and therefore he lost the case. So that is for that one. So I said, held, he could not recover any payment. What was the reason? He didn't communicate his offer to the defendant. So that is for that one. Number 3, very simple. We will not waste time on number 3. We have already done that. The third rule is that invitation to treat is not an offer. So we all know what invitation to treat, and we had a case there, Fisher versus Bell in 1960. So you can make reference to invitation to treat. You can make reference to this case, Fisher versus Bell. So we have talked about that one. So invitation to treat is not an offer. The 4th rule, very simple, straightforward. It says that when you make an offer to a specific person or to a definite person, then that specific person is the one who is supposed to accept the offer. And if the offer is made to a group of persons, then it is that group that has to accept that offer, not a third party. So it means that if an offer is made to a particular group, nobody can accept the offer except that group. If an offer is made to a particular person, that person and no other person can accept it. So if an offer was made to X and Y did it performed it, then Y cannot receive reward. So if somebody made an offer to another person to paint his house, then you heard it, then the next day you went and you painted it. The offer was not made to you, it was made to that person. So if the person doesn't pay you, you cannot take legal action against the person, because the rule says that if an offer is made to a specific person, it's that person who has to accept it, not a third party. So that is for that one. Now, when an offer is made to a specific person, then it results in what we call bilateral contract. Bilateral contract. So a contract, when an offer is made to a specific person, then it is going to result in bilateral contract. The contract will be between the two. But if it is made to a group of people, then it will result in multilateral contract. So a contract between a teacher and let's say the whole class, that will be multilateral. So that is for that one. The fifth rule is what this one to specific person, but the fifth rule is general offer, which we have already learned. We said that, you remember when we were talking about unilateral contract, we said that is a contract that is made to the general public, and the offer is general offer. So if there is general offer, then any member of the public, any individual can accept it. So under unilateral contract, any individual can accept it. And there is a case to support that one. We had Mrs. Kalel versus the Kaboli Smoke Ball Company Limited. So that is for that one too. The next rule is that revocation. Now, revocation. R-E-V-O-C-A-T-I-O-N. Revocation. Or withdrawal. To revoke an offer means to call it back, to withdraw it. If I made an offer to sell my car and I tell that this car, then the next I said that I'm no more selling the car, I have revoked it. So when you are revoking an offer, revocation of an offer is valid only before acceptance. Revocation of an offer is valid only before acceptance. That is why I have written before in bold and I have underlined it. Revocation of an offer is valid only before acceptance. That means you cannot revoke an offer after it has been accepted. An offer cannot be revoked. If I've made an offer to sell my car, then I've not revoked it and somebody accepted it. Once it has been accepted, I cannot revoke it. I can only revoke it before acceptance. In other words, an offer becomes irrevocable. Irrevocable. That means it cannot be revoked after acceptance. So if you revoke an offer after acceptance, that will be breach, and the person will take legal action against you. So that is for that one. The next one, the next rule is that revocation of an offer must be communicated. The offer itself must be communicated, and when you are revoking when you are withdrawing the offer, it must be communicated. I went to an FM station to announce that anybody who finds and returns my passport will be given 500 Ghana cedis. Okay, the next day, or even that very day, I don't want to pay money to anybody who finds and returns it. So I'll go to the FM station again and I'll say that, please, earlier I indicated my passport was missing and whoever finds and returns it will be given 500 Ghana cedis. This time, that offer is no more there. If you find the passport and you return it, I'll not give you anything. Or if you find it and return, I'll give you 100 Ghana cedis. So I have revoked the original offer and I have communicated it. If I did not communicate it, then it is still open, it is still standing. So when you make an offer and you want to revoke the offer, communicate it to the offeree. So that is for that point. So these are the rules of offer, and these ones will make an offer either valid or invalid. Now, this rule about revocation, there is what we call postal rule. Postal rule. Post. What do we post? We post letters. The question here, what we are going to look at here is, I said when an offer is revoked through the post, the postal rule is applied. In other words, you made the offer by writing a letter of offer. You wrote a letter. You have the car you wanted to sell, you wrote a letter to somebody that you wanted to sell your car, and the person agreed to buy the car. Or for the person to either accept or to reject it. So then you wrote a letter. and the person too is in another place. So the person may also have to write a letter to accept it. So you are using the post office. You wrote a letter and then you posted it. So you are using the post office. So it means if you wrote an offer, you put the letter in an envelope, you went to post office, you posted it. It means you made an offer through the post. And there is a rule we call the postal rule, and the postal rule is applied when you use posting to make the offer. Then the postal rule is applied. How did they get the postal rule? There was a time somebody made an offer through the post, and there was a problem with it. So when they went through the case, what the judge said became a rule, and it was then used anytime it happens when you post a letter of offer or acceptance through the post. So that is the postal rule. It is applied when we post letters. Now the question is, how do we apply the postal rule? How do we apply it? So application of the postal rule. There is a case. And this case is the one that we are going to use to know how the postal rule is applied. And that is Bain versus Van Tienhoven in 1880. Bain versus Van Tienhoven in 1880. What happened? Let's look at it. Now concentrate here. I've written some dates here. The first one is 1st October 1. The defendant, you know who the defendant is? The defendant in Cardiff posted a letter to the plaintiff in New York. So the defendant was in Cardiff. If you don't know Cardiff, go and find out. If you don't know New York, go and find out. So the defendant was in Cardiff. He wrote a letter and he posted the letter to the plaintiff. The plaintiff was in New York, offering to sell tin plates to them. He offered to sell tin plates. So the subject matter was tin plates to them. That was on 1st October. So the letter of offer was written on 1st October. Then 8th October, that is a week's time, letter of revocation was written. So he wrote a letter of offer on the 1st, then on the 8th he wrote another letter that no, the tin plate I said I was selling, I will no more sell the tin plate. So he wrote a letter to revoke it on the 8th. So be very careful with the date. First letter of offer, 8th letter of revocation. Then on the 11th, that is 3 days after the letter of revocation was written, the plaintiff receives the letter of offer and immediately telegraphed their acceptance. So this letter of offer that was written on the 1st, the plaintiff from Cardiff to New York, the plaintiff received it on the 11th. So 10 days after the person had dispatched it was received on the 11th. And the letter of revocation was written on the 8th. So it was the defendant who wrote the letter of offer. It was the defendant who wrote the letter of revocation, and the plaintiff received it on the 11th. Then on the 15th, now listen, the moment the plaintiff received the letter on the 11th, immediately, that means on that same day, he made a telegraph. And yesterday, we learned about the telegraph system. You remember when you said as bumper helping, we talked about telegraph, the use of telegraph. The use of telegraph. So it was immediate. So on that same day, he sent a telegraph to accept the offer. To buy. Remember, this one has made an offer to sell. So they have accepted to buy the tin plate. Then on the 15th, he now wrote a letter. The first one, on the 11th, there was a telegraph to accept. Then he wanted to confirm it, so on the 15th, he wrote a letter of acceptance to confirm it. Then on the 20th, the defendant's letter of revocation got to the plaintiff. So look at it too. The letter of revocation was written on the 8th of October. It was received on the 20th of October. The letter of offer was written on 1st. It was received on 11th. Now look at something. By the time this letter of revocation got to him, he had already, or got to them, they have already accepted it, because look at it, it was accepted on the 11th and the confirmation was on the 15th. Then the letter of revocation got to them on the 20th when they had already accepted it on the 11th. Now the plaintiff, why did the plaintiff go to court? Remember, the defendant wrote a letter to sell. They wanted to buy. So if they had gone to court, this one is not selling to them. They said they will not sell. They said, no, you must sell to us. So we are going to court. So they went to court. Did they win the case or they lost it? Hell. Now let me explain this one before I come there. Now what is the rule? Let me now explain to you what the rule is. The rule says that when you are using the post office to make an offer, number one, offer will take place when the letter of offer gets to the offeree. So I have written a letter today. By writing a letter, the offer has not taken place. I will go to post office. Now, no, focus here. Let's say this is a postman or the postman. I've given the letter to him. He put stamp on it. Then I leave it and then I go, or I pick it. Then I go and put in, let's say this is the post office, the letter box. I'll put it inside the letter box. Then I'm gone. Still, offer has not taken place. The post office will pick the letter, they'll put it in van, then they will go to wherever the letter is supposed to go. When they go and they put the letter in the person's letter box, still offer has not taken place. But when the person comes and the person picks the letter and opens the letter and the person reads it, that is where the offer has taken place. So when you are using the post office, you have to find out when offer becomes effective, when offer takes place. And the rule is that offer takes place when the letter of offer gets to the offeree. So it's very simple. Now, number two, when does revocation take place? It's the same thing. You wrote a letter to revoke it. Okay. Then the revocation will take place when the letter of revocation gets to the offeree. So it is when he gets the letter, that is where revocation takes place. So now, let's look at it. That is for offer. Let's look at acceptance. The other person has received it. When does acceptance take place? We know that offer will take place when the letter of offer is when the letter of offer got or gets to the offeree. That's where the offer will take place. But in acceptance, that is not how it is. Acceptance is different. As for acceptance, if I have received the letter of offer, then I write that I have accepted it. I will pick it again, the letter of acceptance. I will go to the post office. I will hand over the letter of acceptance to the postmaster. I will have to write the right address, then the right postage rate. wherever the letter is supposed to go, if I'm supposed to put a stamp that is valued 25 Ghana cedis, and I put it there, 25 Ghana cedis, the address is right, then I hand over the letter to the postmaster. At that point, acceptance has taken place. So you see the difference. For acceptance, the moment the letter of acceptance is posted or it is handed over to the postmaster with the right address and right postage rate, acceptance has taken place. So with this knowledge, if you were the judge, what will you be saying? What it means is that in this case, when the letter of offer was written and posted here, the offer has not taken place. The offer took place when the offer was received on the 11th. So the offer took place on the 11th. So offer took place on the 11th. Now, he had written letter to revoke it on the 8th. But the revocation, when did revocation take place? Revocation took place, the federal letter of revocation got to. So here, it took place on the 20th. So revocation took place here. Revocation took place here. Take note of that. What about acceptance? Acceptance took place here. The very day he sent the telegraph, and then you receive the telegraph, it has taken place. Then they even wrote a letter to confirm it. Now the letter that they wrote, as if they haven't even sent the telegraph. As for the letter, the day they went to the post office to post it, if the address was right and the postage rate was correct, then acceptance has taken place. So what it then means is that, so number one, revocation of offer is not effective until it is communicated to the offeree. So that is one. Until it is communicated to the offeree. A mere posting of a letter is not revocation. So when you posted the letter, you have not revoked it. So in this case, the revocation was not effective because by the time they receive the letter of revocation, acceptance has already taken place. So acceptance, once acceptance has taken place, it cannot be revoked. It cannot be revoked. Acceptance took place on the 15th, so it can never be revoked. The letter of the revocation took place on the 20th. Acceptance on the 11th. On the 11th. So it can never be revoked. So the revocation was not effective. The revocation was not effective. So let's note that one. And we have talked about that. So that is what I have summarized. There. I said letter of offer, when it's received, that is when the offer will take place. Letter of revocation received, then revocation has taken place. Letter of acceptance posted, then acceptance has taken place. So that is for that one. I'll give you an exercise. And I'll be asking when revocation took place and so forth. So that is for that one. Now, what says, how many minutes have we spent so far?
33 minutes.
What?
33.
33. Okay. Now, let's see whether we'll be able to add the termination. Termination of offer. What is termination of offer? It's very simple. It means the offer has come to an end. It's very simple. You remember when we were talking about types of offer, we talked about standing offer. When an offer is standing, it hasn't come to an end. But when it is terminated, it means it has come to an end. When you withdraw an offer, it has been terminated. So when you say an offer has been terminated, it means it has come to an end. We are looking at ways by which an offer can be terminated. Ways by which an offer can be terminated. Number one, very simple, straightforward, lapse of the offer. That's the one, lapse of the offer. There is E here. It's lapse of the offer. Lapse. L-A-P-S-E. Lapse of the offer. Lapse of the offer. When the offer lapses, then it has been terminated. We are going to look at three things under lapse of offer. When you say an offer has lapsed, what makes an offer lapse? Number one, death of the offeror or death of the offeree. When somebody makes an offer and the person dies, the offer has lapsed and therefore it has terminated. The person to whom the offer was made, if the person dies, the offer has lapsed and it means it has been terminated. So that is number one. Please, what I'm saying is that lapse of offer has three things inside it. The first one is either the death of the offeror and the death of the offeree. The second one is passing of time. Passing of time. Passing of time. When time passes. What does that mean? If I made an offer to sell a car and I said by Monday, if I made an offer today and I said by Monday 10 a.m., if the offer has not been accepted, it is terminated or it has lapsed. That means on Monday 10 a.m., if nobody has accepted it, nobody can accept it after 10 a.m. So if you come to me at 11 a.m. and nobody has even bought the car and you say you want to accept to buy it, the offer is no more exist because time that was indicated has passed. So that is what is meant by passing of time. At your level, maybe this may be okay, but at another higher level, somebody may say, what about the situation where you did not state the time? In law, they have what they call reasonable time. They will look at what we call reasonable time. Reasonable time. And what is reasonability? It will depend on the subject matter. It will depend on subject matter. So, if you look at this one, passing of time, there is a case to support.